Oh, you're still doing that? Yeah. Do you do it every week?
Yep. Yes, ma'am.
At the roller disco?
Not yet, but yes, at the roller cave. Don't be afraid to fall.
Oh, I hate to fall. Whether that's
It's
skiing,
inevitable.
skating, anything, I hate falling.
Oh, I don't know anyone
The
who
more you
likes to
do it,
fall.
the easier it gets. It really does. It's like, just get up. Of course, the goal is not to fall, but it's inevitable.
Hello. Are you Jonathan Dreamer? Charles Smith? All right, he used to go into custody. Sylvia Noriega? Is she in custody?
No, Judge, she's not in custody.
All right, is that a motion to revoke?
Well, it's a summons. This is the one where she still owes restitution to a company.
Ah, okay, I remember that.
Yes.
All right, Keith Adams is in custody, Roxanne Hutchinson custody. And Victoria Sanchez custody. DeAnthony Gordley custody. And then we have Sylvia Noriega.
She should be on Zoom, Judge.
She's not. And Deputy Laura, we're gonna start trial exactly at 10. So any attorneys who are not here, they're coming back.
I won't say a word, Judge.
Okay. All right, Vashawn, Superman is on my list.
Actually, I think, Toria said last night that it's on Amazon Prime.
Already, all right.
But I think it's for a price, Is it? I don't know. I didn't go on there and check.
It would be.
That and, another recent movie, I remember.
Well, that says something that's not right.
I liked it.
No, I'm gonna say it. I'm gonna keep an open mind and I'm not gonna put it in the stratosphere before I watch it because sometimes people will say movies are so great and you have it up here, but then it's here, but your expectations were too high.
I'm not gonna say it's so great. I'm not gonna say that. I'm just saying I enjoyed it.
Is it better than the original?
I don't think.
Thank you, Duffy.
We just want to make sure you can be fair and impartial when you go to watch this.
Dun, 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 dun. Yes, I will be. But I can't believe it's already on Prime.
So it wouldn't, it's certain movies that hit the theaters.
Mhm.
So you'd be paying like $30 to have it for 48 hours. So it's not like on Prime
Oh,
available for those who have the membership.
Oh.
Like you have the membership, but you're gonna have to pay extra and you don't get to keep it.
oh, I'm not paying $30.
Yeah, it's like going.
Yes. And there is some new movie that is coming out that somebody said you have to watch on IMAX. I'm trying to remember what it was.
The new Jurassic Park?
Yes. But should I go see that? People are always doing silly things with Jurassic Park.
My friend told me just to hold on. It's not as. I really want to see Jurassic Park.
My
I like
parents said it was so good.
It was Tracy, my friend Tracy said
And
that,
they liked
and,
it. And they like it.
and they like all of the movies, and she said,
That's what my parents said.
you're better off waiting till it streams.
Yeah, I asked them, would you go see it again? He said, no, just wait till it.
Well, I mean, but I will tell you, there are movies that I would rarely see again. Like Big Trouble in Little China, I can watch that all day long.
Is that your movie, Judge?
Yes, and Army of Darkness, I can watch that all day long. Cause
Flip my movie,
what?
I could watch Grease 2 and Urban Cowboy.
Okay, I could watch Grease too,
And Urban Cowboy. I like Urban
depending on the
Cowboy.
mood I'm in with Grease too. Urban Cowboy,
I
not
like
so
it.
much.
I like it.
And I could watch Critters over and over. I remember watching Critters. I think the first time I saw that was at the drive-in. The drive-in movies were so great. All right, Mr. Ramirez, who do you have?
Morning, Your Honor. I have DeAnthony Gurmont Gordley.
All right, could y'all bring him out, please?
Oh, not the jail.
He's supposed to be on Zoom because I requested him to be on Zoom yesterday, so I'll call the jail.
All right,
Like when you requested.
okay. All right, Mr. Ramirez, have you had a chance to speak with the state on your case?
Yes, Your Honor. The state, the last time we spoke was well, kind of ambiguous on their position. They were, I think that's what we were waiting on to see what ascertaining his what he was going to do on it.
All right. Could I see the file on DeAnthony Gordley, please?
Yeah, he was supposed to be on yesterday when I just, they picked him up from the jail, brought him over the jail down till Sunday. Thank you. Bye-bye. They're gonna get him on to
Okay.
in a few minutes, just so you can give him a few minutes.
He's not here.
Oh, it's hot in here.
No. Because, no.
When are they gonna fix this?
They're not going to fix the AC.
We didn't have an AC and it was really, really hot. So I really hate people that complain it's cold in here.
Judge Tedwood said he'll be on his way, he's just in trial in children's court. But he'll-
Sorry, who?
Ted Woods.
Oh, well,
he's-
if he's not here by 9:40, then he's gonna have to be in the afternoon.
They're starting to try to look at the town.
Thanks.
Those two cases first.
That's it. You think about it, I just say it. Yeah. But anyway, I think my we did German, it's a range. It's basically quarter one, it's full rain, full weight. confident?
How you doing this one? Well, I'm doing sharing. Should have traveled. We can set up. No, but I understand. They said, try to come by tomorrow. Fine.
Oh,
So I'm
okay.
trying to set up, but, try to figure out some time. They have, it's a motion to travel, we'll need to just get it. I understand we can do Zoom, that'd be awesome.
Yes. When did you want?
I'm gonna do it separately. Okay.
We're actually control.
Okay. I can, let me ask. I can get her. Then. And then I need to get. Let me work on one. Okay, let me work on one. Okay. That 824, so.
Yeah.
So page one on the bottom.
Okay. Awful, yes. Here, for you. This is my second time. You off the roll, it's 3 hours. Bro, rock. Motion. Grab the motion. Go ahead. Jason Wolford. No. Like when you trim. Oh. I don't know.
Just give me a moment.
Thank you. Standard pick, they did a great job. Windshield washer as well, and they didn't fill it. Kind of like that's fine. But now they sent me, please give us a review. And I'm like, you guys didn't finish. Well, my windshield washer. Like I think that's like basic.
Yeah.
I don't even want the booze going for them, just water. What do they call it? I don't know why that matters, because it's like $3. It's like the one thing on the car I can do myself. But I'm still like, y'all didn't do it. You give me 4 stars. Read that. Like a $5 bottle of water is worth it.
Here.
One of them.
She's running behind. We can approach. Yeah. She's. Andrea. Yeah, she's running a couple times. So I told her. Not so hot in here today. It's hot. It's not bad, but it's not like. It's because we don't have as many.
Yeah. The added body heat. Isn't apparent today.
Thank you.
Todd,
Yes, sir.
hey, you ready?
Yes, sir. May I?
Yes. Good morning.
Good morning, Judge Boyd.
Good morning. All right, so they've requested a travel.
And I'm standing in for proceedings, Samantha Brown. She has no issue with that, Your Honor.
Okay. All right, so what we'll do is you'll be allowed to travel, but you're gonna have to do a UA when you return. Do you understand?
Yes, ma'am. That's
Right.
perfectly fine.
All right, and you'll just do that through your probation.
Yes, ma'am. I need to email my probation officer to let him know about the travel permit as well?
Oh, I'm signing the document now, and so
Okay.
they'll receive it.
Okay.
All right, is there anything else?
Nothing else,
No,
Your Honor?
ma'am.
Are you doing well on probation?
Yes, ma'am. I already finished anger management, hostility management. I am about halfway through MRT. I'm ahead on my payments for probation and just moving forward.
All right, great. Keep up the good work. Again, if you need anything, just let us know, okay?
All right. Thank you so much. I hope you have a great day.
Oh, thank you. I'm gonna do my best. And thank you for dressing appropriately for court and being on time.
You're welcome. Thank you for everything.
All right, bye-bye.
Bye-bye.
All right, just make sure, Vashawn, on this case, they'll give you, I guess, a copy if you need it. All right, so if you'll have a copy made
Yes, Judge.
and then give the original back to the clerk, but if you'll make a copy for Miss Abrams.
Of course, Judge.
All right, thank
May I
you.
be excused? Judge?
Yes, thank you. Yes.
Thank you, Judge. Have a great day.
All right, you too. Bye-bye.
Bye-bye.
Thank you.
All right, we're here on DeAnthony Gortley. And I think it's for a bond reduction. All right. Are you ready to proceed on this?
Yes, Judge.
All right, the court is calling 2025 CR 0070068 State versus DeAnthony Germonte Gortley. Could I have parties announced?
Docket for the state of Texas.
Robert Ramirez for Mr. Gordley, Your Honor.
All right, and Mr. Gortley is here by Zoom. Defense, do you have any objection to your client being present by Zoom?
No, Your Honor.
State any objections?
No, Judge.
All right, Mr. Gortley, if you can unmute for me, please. All right, hello, Mr. Gortley, you're appearing by Zoom. You can be allowed to appear in person in court. Do you have any objections to appearing by Zoom?
No, ma'am.
All right, so I'm gonna mute you now and again because sometimes there's noise that comes from your end because it's at the jail. So,
Understand.
all right. All right, so we're here on defense motion requesting a PR bond or either to reduce bond. Is there an agreement or no?
The state does not believe there's an agreement.
All right, and state you're opposed to the PR bond?
Yes, Judge.
All right, and why are you opposed to the PR bond?
The state would argue just the type of offense and that the state believes the original bond set, I believe it was 7,500, would be appropriate for this offense. And yeah, that's the state.
All right, so, and defense? What I can tell
Your
you
Honor.
is based upon what he's charged with and based upon the new based upon what the governor has stated and given to the court, I'm not allowed to give him a PR bond for harassment of a public servant. Those are not my rules. These are the rules that I must follow. I tell everyone, it doesn't matter how I feel about something. I'm just going to follow the law. So he's not entitled to a PR bond. The court is not going to grant him a PR bond. We can talk about the bond reduction though. And if you would like to present evidence.
Yes, Your Honor. I'd like to call my client to testify on this case.
All right, Mr. Gartley, if you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
D'Anthony Germonte Gordley.
All right, sir, you may proceed.
Mr. Gordley, have you tried to make bond on the 7,500?
Yes, sir, I have.
And why have you not been successful?
Uh, I don't have like the resources or the people out there to help me. So I've been in here by myself trying to do it.
Well, what about your mother and father?
They're both deceased.
Okay, and I was aware of that when I asked that question. I just wanted to make that for the court. Well, what do you do for a living?
I dance and basically just make videos and I work
Okay.
when I can, but I can't right now.
Were you able to save up any money while you were working as a dancer and making videos?
I was, but I don't have any access to my funds because I don't have my wallet in here, nor do I have my phone.
Okay. I've spoken with your sister. Has your sister been able to make contact with these funds?
No,
Okay. And where does she live?
she actually lives with someone that I don't even know.
Okay, but she's not in San Antonio area?
She's just not stable.
Okay. Um, so okay. Um, but you understand that you would have to make, we talked about the PR bond. The court just told us that this offense does not qualify as a PR bond. Um, so uh, if the court could reduce the bond to a certain amount, would you be able to possibly make that with possible assistance from outside?
I'm not 100% sure, but it's possible. It's possible.
Okay. All right. I have no further questions, Your Honor.
All right, any questions?
No questions from the state, Your Honor.
All right. Mr. Gortley, I just have a few questions. Any objections to the court asking a few questions?
No, Your Honor.
None from the state.
All right, Mr. Gortley, have you ever had any type of diagnosis for mental health issues?
When I was younger, I think it was ADHD, but I don't, nothing since I've been grown.
Have you ever been prescribed any type of medications for mental health?
Not that I know of, no, ma'am.
All right. Have you ever in the past used any type of controlled substances?
If weed is a controlled substance, yes.
Yeah, it counts as a controlled substance.
Well, yes, ma'am.
Anything other than that?
No, ma'am.
All right. And do you have any type of, I know your counsel said that, asked you whether or not you had funds, and you said you don't have any access to those funds. Is that correct?
Yes, ma'am, correct.
All right. So if you had access to funds, how much approximately would you have access to?
Honestly, I wouldn't be able to tell you that exact amount because so I get paid from Facebook and Instagram and TikTok and stuff like that because I post videos.
Okay.
So I don't know. It varies every month. It varies. It could be 200. It could be 1,000. It could be something within that range. But I don't know for sure because I didn't get to post as many videos as I did since I've been in here. I've been in here, going on 5 months now. So I don't have, I wouldn't be able to tell you exactly what's there because it's not residual income.
Okay. And I have no further questions. Oh, I'm sorry. One more question. If you are able to make bond, where would you have a place to live?
Yes, I will.
Would you be living with anyone?
Yes, I would.
And who would you be living with?
Most likely my girlfriend.
And does she have any children?
No, ma'am.
All right, so there would be no minors in the home?
No, ma'am.
All right, thank you. All right, State, do you have any information on Mr. Gortley's criminal history?
Yes, Judge, give me one moment. The state sees minimal juvenile history, but in 2018 probation for an unlawful carry of weapon. And that would be the extent of the history, Your Honor.
All right, no violent history?
No violence.
All right. Then, Mr. Gorley, one final question. What amount of bond are you able to make?
Honest, I don't have any funds right now. Like I would have to reach out to my people and see what they will be able to come up with, but I wouldn't be able to even tell you a number. I don't even want to lie to you, Judge.
Oh, no, no, no. I'm just trying to figure things out. All right, so the court is going to grant the motion to reduce bond. State, I know that you're not in agreement to the reduction of the bond, but you now know that the court is going to reduce the bond.
Yes, Judge.
So is there any request from the state with regards to a reduction in the bond?
The state would rather hear defense's suggestion and be able to agree with it. if
All right,
that's
thank you.
possible.
Yes. All right, defense. What are you requesting for a bond amount?
$500, Your Honor.
The state was hoping he'd say 1,000, but the state would not make a very effortful fight against said suggestion.
All right, I'm going to set his bond at $1,500. There's to be no residing with minors. All right, and if for some reason he's unable to make the $1,500, counsel, you can always come back and you can come back immediately. But
Your Honor.
my hands are tied, and we can go off the record. My hands are tied in the sense that he hasn't really expressed to the court the amount of money he has access to. So we'll start out with $1,500 and see where we are.
Yes, Your Honor.
All right, thank you.
Thank you, Your Honor.
Thank you.
You're
Thank y'all
welcome.
so much.
Thank you.
Thank you all. That being all may be excused, Your Honor.
Yes.
Okay.
All right, Michael, you know how when you first leave law school, nobody ever talks to you about what is the appropriate amount of bond you should ask for somebody. I remember one of my first cases, my client had a first-degree felony drug charge, and it was closer to the 400 grams, right? And so Bert Richardson was the prosecutor. Judge Hall was the judge. And so we go back into his office, and he's like, yeah, what do you want this bond set at? You know, and I'm not, in my mind, I'm like, $50, you know, can we do that? It ended up being 1,200. But let me just tell you, with a straight face, I said, well, I know for a fact he can make a $50 bond. We're just here to make sure that he appears.
Thank you.
But since I've been judge, there have been some judge set somebody's aggravated robbery case. I'm not going to say who it was. They set it at $200. And then they come to me and they want a bond reduction. I'm like, no. I said, do you know what a bond at $200 means? That means that you don't know 20 people who will pay, you know, well, $200, right? And then I said, you got to know at least 10 people who will say, you know what does that say? And then that same person, they went back to them, and that bond, they reduced it to $50. Then they come to me and they want me to reduce an aggravated robbery case below $50. I'm like, no, you don't know 5 people who will give $10. What does that say? So I was just like, no. Oh, excuse me, sorry. Hello?
9:40.
Yeah, we might.
Yes.
I'm just trying to check, Judge, to make sure my client is on Zoom. It should be Noriega.
All right, it's somebody with a Samsung. Is that her?
I wouldn't know, because I didn't log on because I was in court this morning, so I just came up.
All right, the person with Samsung, if you could unmute, please, and show your video.
Hello?
Hello, if you could start your video, please.
There, okay.
Oh, hi.
Hi.
All right,
That's
so
her, Judge.
yes. So on Noriega, have we figured out?
I think Ms. Abrams may want to give the court an update.
Okay, Judge. All right.
Apologize.
Oh, no problem. So what is the update?
Okay, so Judge, Miss Noriega, the last time she was here in court, not yesterday, but previous to yesterday, because I wasn't here, she indicated to me she was going through bankruptcy.
Yes.
So I wanted to make sure that the court was aware of that. What I found out as far as her fees are concerned is, the original assessed fees total combined was $8,879.75. Of that, the restitution was $5,448.75.
Mhm.
The probation fees that she's paid is $1,108. The restitution that has been paid was $2,454.57.
I'm sorry, 2000. Oh, thank you.
Have this, Judge, I wrote on there.
Okay, thank you.
So the remaining balance of the restitution, you can see is a little over $2,000. Even if we do a modification priority of fees, they're not gonna get, they're only gonna get $1,100
Mhm.
for that
2000.
$2,994. I did print out a modification of fees for that, in case the court wants to go ahead and sign it. It is to Xerox, the Xerox Corporation. At this time, probation is just asking for the case to be terminated. I think that's what it is.
All right, so if you're saying that $1,100 would go to the 2,900?
Yes, Judge.
Okay. All right, and as a part of her bankruptcy, I'm familiar with bankruptcy, not from my own personal, that I've had bankruptcy, but I've known other attorneys who practice bankruptcy law. And usually, if you're going through a bankruptcy, all of your debt is within that bankruptcy, and people will claim their debt and the creditors will be in line. Now, it's been a while since I've been in law school, so I don't remember. I think it's secured creditors come first. And then, so Xerox should be in that line of creditors in the bankruptcy. It should come up that she owes them money. And so that's a civil matter. So here's my question. Other than the remaining balance of the approximately $1,300, which Xerox should get through the bankruptcy, is there anything else that she has not completed?
No, Judge, and I'm sorry, you said 1,300?
Well, you said you're taking like $1,100 away from the 2,900.
If you sign the modification of fees, Judge.
I'm going to sign the modification of fees. So then.
She's
that-
completed everything else.
All right. All right. So here's the thing, Miss Noriega.
Yes, ma'am. I wanted to say something.
Yes.
Okay, so the bankruptcy, because I live with my dad. I take care of my elderly dad. He's 80 years old. And we had a situation where my sister was in charge of his finances and she was taking his money. So the house wasn't getting paid, and that's why my dad is in the bankruptcy. I help him because I live with him. I'm not the one in the bankruptcy, my dad is, but I help him contribute because he gets Social Security and a VA check, and that money goes to the bankruptcy payment is 1,230. So all my other monies that I get, I pay towards everything else, and that really leaves me with nothing. But I mean, I was not going to pay one of my bills so I can, contribute to what I owe.
So, all right, well, I thought she was in bankruptcy, but it is not, it's her father.
No, it's my dad. Yes.
Me too. All right, so then you're not in bankruptcy, the money needs to be paid to Xerox. So how much are you able to contribute to Xerox?
How much time do I have?
Just give me one moment.
Okay.
See. All right, so her balance then will be approximately $1,300. So once you pay the $1,300, the court will terminate your probation.
Yes.
So
ma'am.
when are you able to pay that?
I'm not sure. I would have to make payments. I mean, at this point, I mean, I'm already, financial burden, but I'll figure something out. I don't know when I can actually have it all, but I'll pay something every week because I get paid weekly. I can
Mhm.
pay, I mean, at least $100 a week. I'll start paying that.
Okay. All right. Thank you so much. Probation will be in contact with you. Okay.
Okay.
All right. Thank you.
Thank you.
We can't amend conditions or anything like that.
No. All right. Probation will give you a phone call. Okay.
All right. Am I free to go?
Yes, you're free to go. Thank you.
Thank you.
May I be excused, Judge?
Yes, thank you. And everyone, we're starting our jury trial at 10. So anything not completed, you'll need to come back this afternoon.
Judge, I'm gonna be ready in about 3.5 minutes. I've started my paperwork.
All right, we're starting the jury at 10. So
can turn it on.
And has your client been sworn in?
No. Oh, wait, Judge, should we have a wrestling match here? Remember? We could do that.
Oh, you can.
Absolutely.
I don't know, if anybody will lay any bets on anything.
I don't know. We could do a YouTube.
Do you remember, MTV, they used to have the celebrity match, the claymation?
Yes, I do. Celebrity that match.
Yeah. Oh, that was funny.
It was.
You know, I was, walking and somebody had on a t-shirt and it said Pickle Rick. And I'm like, Pickle Rick? And he and I knew. You don't know about Pickle Rick? Rick and Morty.
Oh, didn't watch Rick and Morty. I never got into it.
Oh, you should see Pickle Rick, that episode.
All right. My daughter finds it hilarious, that and BoJack Horseman, which I've heard has taken a really depressing turn. BoJack Horseman's really popular, but with the same people who like Rick and Morty. So
Okay, and it's BoJack what?
BoJack Horseman. It's like
Okay.
a horse who lives like a human being and is voiced by somebody famous. I can't remember.
All right, I'm gonna have to see what's going on with that.
Tackles a lot of controversial issues.
Oh, dear. Yeah. It's sort of like the Boondocks then.
BoJack Horseman.
Yes.
All right, Charles Smith, come down. Court is calling 2024 CR 1894 State versus Charles Smith. Can I have parties announced?
Scott Simpson for Mr. Smith.
And are you Mr. Smith?
Yes, ma'am.
Counsel, have you received all discovery in this case and did you review it with your client?
I have, and I did.
Court will find that the state is in compliance with discovery. Is there an application in this case?
Yes, Judge. For regular, not for deferred.
All right, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we are not. We are proceeding with the lesser included attempted fraud use possession to make this a class A misdemeanor.
Any objections?
No objections, Judge.
Did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand the state is proceeding on the lesser included offense of attempted fraudulent use or possession of identifying information less than 5 as a class A misdemeanor? Range of punishment is up to a year in the Bexar County Jail and up to a $4,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has,
Do you believe he has a rational as well as a factual understanding of the charges against him?
very much so.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Smith, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand that?
Yes, ma'am.
According to the plea, punishment is to be assessed at 365 days in the Bexar County Jail. The state recommends community supervision. There's to be restitution to St. Peter and Paul of $1,940. There's to be no contact with St. Peter and Paul and the MRT. Did you understand that to be a plea?
Yes, ma'am.
Defense, is that the plea?
It is.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
None.
Outside the agreement, the state is recommending their community supervision be for a term of 2 years. There be 100 hours community service restitution and no contact with St. Peter's and Paul. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense, the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
State offers State's Exhibit 1 and all attachments at this time, Your Honor.
And we've reviewed those, Judge. We have no objections.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same.
Yes.
All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. So here's my question. Did Frost Bank receive their money back or no?
No, I don't think.
Or did Frost?
Adopt it, so the complainant would be good, but I do believe Frost may be out.
All right, so do we know if Frost is out of 1900?
I can call and confirm. What I do know is that based on the STIPs, there were multiple missing things that the state did limit to defendants' participation, but the state can get a confirmation and if there will be a restitution hearing.
I believe in what I've worked on it, that restitution was not made yet to Frost. My client understands that and is prepared to, knows he has to pay that over the course of his probation. We've already calculated how much he has to pay each month to get it caught up. So I think it should be ordered, Judge.
All right, and so with regards to the $1,900, when do you expect you'll be able to pay that?
How many months?
I can do it within 2 months if I need to.
To be realistic, don't.
Realistically, within a year.
6.
Yes, 6 months to a year.
So how much money can you pay down?
Down,
Today, like today. You're talking today, right, Judge?
Yes.
today 0. Just in all honesty.
All right, so when will you be able to make a payment of $800?
Next Friday.
All right, so what I'm gonna do is I'm gonna reset this for next Friday. You're to come in with the payment of $800. Probation,
Following Monday, Judge.
the following Monday? All right. Oh, yes, no,
Thank you.
What date is that, Judge?
let me pull you up. The 28th,
28th of July.
January 28th.
Yes,
I'm
ma'am.
sorry, July 28th.
Yes, ma'am, absolutely.
Also, we're gonna recall for July 28th,
For 800 then.
and you're to make a payment of $800.
And
And who does he make that out to? Probation, state?
Actually, it's gonna be part of the state. If it's not
Well, I'll communicate with the prosecutor between now and then, Judge, but it's gonna have to be in a cashier check or money order. So I'll get that info to you and I'll talk to Mr. Pitluck.
All right, and then your client was late today.
I understand, Judge.
Yes.
I would ask if you could recall the warrant and let him out so he can get this money
Yeah.
for next Monday.
State, do you have any objection to the court recalling the warrant so that he can obtain payment?
No objection from the state, Your Honor.
All right, we'll recall the warrant.
Thank you, Judge.
All right, thank you. Make sure you're on time. So your next court date is going to be July 28th. They're going to give you a reset form. Court is in the courtroom, okay?
Yes, ma'am,
All
absolutely.
right, thank you.
You.
And Deputy Laura, could you see if the jurors are all here? Who's here on Victoria Sanchez?
Here for a judge.
Court is calling 2020 CR 2715 State versus Victoria Sanchez. Can I have parties announced?
Deputy Pitlock for the state of Texas, Your Honor.
Come forward.
Ted Wood representing Ms. Sanchez.
And are you Ms. Sanchez?
Yes, sir. Yes, sir.
All right. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney?
Yes, ma'am.
And also the First Amendment motion with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Are you the same Victoria Marie Sanchez who was placed on deferred adjudication in 2020 CR 2715 for the offense of possession of a controlled substance penalty group 1 gram to 4 grams on August 5th, 2020 for a period of 2 years? Is that you?
Yes, ma'am.
And extended for a total of 5 years?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violation of condition number 28. On or about the 11th day of April 2025 in Liberty County, Texas, the defendant Victoria Sanchez did then and there fail to comply with the rules, regulations, or instructions of the Bexar County Community Supervision and Corrections Department Substance Abuse Felony Punishment Facility Continuum of Care Treatment Plan, that the defendant was unsuccessfully discharged for refusing to participate in treatment in violation of condition number 28.
All right, so what motion are you reading from? Because I don't see a violation of 28 on mine.
This was provided, it's under case number ending in 2715.
Is it a supplemental or something?
No, Judge, it was signed 5/13/2025.
May I show the court?
Yes, because I don't have that one. Okay, yes, I've been given the wrong paperwork. Okay,
Rely on the defense to give you the right paperwork.
okay. So to that allegation, how do you plead? True or not true?
True, Your Honor.
State, do you waive? Is that the only allegation?
Seeing that this is the only violation.
All right, yeah, I definitely didn't have the correct paperwork. All right. Did you understand by pleading true to violation of condition number 28, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition 28?
Yes, Your Honor.
Court will find violation of condition number 28 true. Is there a proposed agreement?
There's not, we are going open, Your Honor.
All right, state, what are you requesting?
The state is requesting that you grant the state's motion, revoke probationer and sentence probationer to 2 years TDC.
And defense, what are you recommending?
Judge, right now, this morning, Ms. Sanchez has 180 days credit. I'm asking the court to find her guilty of the lesser included offense of attempt to possess controlled substance 1 to 4, which is a state jail, and sentence her to 180 days in state jail, time served, judgment satisfied.
All right, why would I do that? She hasn't been successful.
Because you're a merciful and just judge.
Yes, but she has been, this is not our first motion to revoke.
It's not, Judge, and I think that Ms. Sanchez is having difficulty utilizing the resources available through SafeP. I don't think that there's any sort of remediation that is available to her that's going to help her move forward with her life. And Judge, I'm asking that you sentence her to 180 days, time served, judgment satisfied, so that she can get out, rebuild her life, Judge, she's a victim of sexual violence, and I'm hoping that when she does get out, that she can link up with Center for Healthcare Services and get some trauma therapy so that she can go forward with the rest of her life.
All right, and you have children?
Yes, Your Honor, I have one.
All right, and see, that's the problem because she was here when I placed her on deferred adjudication. I placed her on 2 years deferred adjudication, gave her all the tools that she could need, had her saying, work with CPS, had contacts for her for outpatient treatment, intensive outpatient treatment, did a referral to felony drug court. Then there was a violation and still continued her, did the weekly Zoom reporting to try to get her on track. And then there was another violation, and then she was sent to safety. So I'm not going to give you a judgment satisfied. I'm finding, and did you complete the CPS?
Yes, Your Honor, I'm actually getting my visitations. I was paying my child support for about 8 months, the last time you sent me for the 2 years. Within those 2 years, I did 8 months, I think up to 9 months of job and paying my child support, and I was seeing my kids. So
Mhm.
I mean, right now I'm really having a hard time with my son, he just started middle school, so he.
Well, you know why you're having a hard time with your son? Because you're not in his life.
Exactly.
All you had to, yeah, well, you're saying exactly, but all you had to do was complete this probation. And I don't know if you would be a good influence on your son because I don't know if you're still using drugs or not.
I understand that, Your Honor, but I feel like this has been the longest I've ever been locked up my whole life, and I think I've changed a lot, and I think I've learned the lessons that I need to learn to go out there
No.
and work and be there for my children.
You haven't learned any lessons because we're here on another motion to revoke. And I always tell people, if you're not going to be clean and sober for yourself, which that's how you should always be, do it for your children. If there's somebody else you love more than yourself, do it for them. And you're not even doing it for your children.
I am, Your Honor.
And so that is why your son is having problems because you're in and out of his life. Sometimes you are there. Sometimes you have motions to revoke. Sometimes you're using drugs. Sometimes you're not. That's instability for your child.
I
And
understand.
I'm not going to reduce this, and I'm not giving you a judgment satisfied. I'm finding 28 true, going to find you guilty, revoke. I'm going to sentence you to 3 years in the prison, give you credit for any time served. I'll request the therapeutic community. She'll receive any credit for successful inpatient treatment.
Very well, Judge.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, I did.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
We can go off the record. When you're released from prison, if you can't find a sober house, if you can't find someone that can help you, if I'm still here, you come back here, I'll pick up the phone, call somebody to try to get help for you, okay?
Alrighty, thank you. Your
All
Honor.
right, you're welcome. Good luck to you. Are they all here?
Yes, Judge.
All right.
Excuse, Judge.
Yes.
Thank you.
Then we will start with them,
We have 2 more inmates. Do you want us to hold them or do you want to do?
if you'll hold them,
Downstairs or?
downstairs.
Keith Hutchinson. Your Honor.
And can I see the file on Dreamer, please? All right, Mr. Dreamer, if you'll come forward, please. Hello, good morning. Your attorney has a family emergency, so they're not going to be here today.
Understood.
So what I'm going to do is I'm going to recall you. Norma, recall this for August 18th. And that'll be for you to get your jury trial date. All right, so once you sign the reset form, you're excused. And thank you for dressing appropriately for court. You're welcome.
You're the bestest. I know you like that. I did. I'm so grateful. I'm glad you loved it. Yes. Open one, this.
Yeah.
Mr. Freeman?
Oh, and if you'll take the witness stand, please.
And if you could just give us a moment to set up, Judge.
Sure. And if you'll make sure you put on the microphone clip, please. Just give us 2 minutes. All right, the court is calling 2023 CR 10004, State versus Tyler Ashbaugh. Can I have parties announced?
Megan Galloway and Jason Garringham for the state of Texas.
Nathaniel Navy and William Salazar for Mr. Ashbaugh.
And are both parties ready to proceed?
The state's ready, Your Honor.
Defense is ready, Judge.
All right, Deputy Laura, if you could have the jurors come in, please.
All rise for the jury.
Judge's microphone's not working.
All right, we'll have to see why that isn't. There may be, I don't know if something was turned off up here. Deputy Laura. Thank you. All right, thank you. All right, everyone, please be seated. We're good? Oh, yes, we are. Thank you. All right, you're still under oath. All right, states you may proceed.
Your Honor. Mr. Ashbaugh, from what I gathered from your testimony yesterday was, during this time in May 2022, you weren't really being that great of a human being during that time. Would you agree with me?
Yes, I would.
Okay. And so, in speaking about your relationship with your father during this time, it was kind of a rocky time in y'all's relationship, right?
Yes, ma'am.
Okay, because he's providing you his motor vehicle, and you're feeling like he's not really doing enough to help you at 22 years old. Is that fair to say?
At that point in time, yes, it was.
Okay. And, your father, at that point in time, he was expressing to you that he wanted to see you and your daughter more. Is that fair to say?
Yes, it is.
Okay, and that was causing some friction in y'all's relationship, right?
Yes, it
And
was.
so now you can understand the context of why he was saying the things that he was saying back then that upset you, right?
No, as a father, I still wouldn't say those things to my son.
Okay. And so you are saying that he was calling you by your biological mother's name, is that correct?
Yes.
Okay, and so that's what really upset you.
Yes, it had.
Okay, but your father at that time, he felt like you were using him. You would agree with me, right?
Yes, he did feel that way.
Okay, because you're taking his motor vehicle for a period of time, right? He's asking you to return it, right?
Yes, he did ask me to return it.
And you're not complying with that, right?
Yes.
Okay. And so yesterday you said that you had the motor vehicle for about 2 or 3 days. Is that what you said yesterday?
Yes, I believe so.
Okay, but I guess let me show you. I'm going to show you what has been marked as State's Exhibit number 65. If you could just take a look at this for me. And does this appear to be the text messages between you and your father?
Yes, it does.
Okay. And so if we look at these text messages in conjunction with your father's testimony, during this time in 2022, you stated that your motor vehicle, the Sentra, that was your vehicle, right?
Yes, ma'am.
And you stated that the transmission was out, right?
Yes, ma'am.
And so during this time in 2022, your dad had actually given you money to get the transmission fixed, right?
Not that I can remember.
Okay, can you go ahead and refresh your memory as to that?
He's referring to just giving me money in general, as in gas money and things like that.
Okay. Did you tell him that you were gonna use that money to fix the car?
No.
But that's what he's saying, that you told him.
Judge, I'm gonna object that the question contains hearsay.
The objection to hearsay as to what the father says, that will be sustained.
Okay. So you're saying that, he gave you money for other things,
Yes, ma'am.
but your dad could have a different view of that.
Objection calls for speculation.
Sustained.
Now moving on. Your dad asked you for the vehicle back.
Objection, the question contains hearsay.
That will be overruled.
On May 14th, 2022, did your father ask you for his motor vehicle back?
He said, "Where is my car?"
Okay. And did you take it back to him on that day?
No, I didn't.
And then again, on May 16th, 2022, did your dad ask you for the vehicle back?
Objection, hearsay.
Overruled.
You can answer.
He was asking me when I was going to be returning his car.
Okay, and did you tell him when you were going to return it?
No, I just told him I wasn't feeling well.
Okay. And then again, on May 18th, 2022, was your dad letting you know that he wanted the car back? I can unclip it. Hold on.
Yes, he was.
Okay. And then again, on May 20th, did your dad ask you for the car back?
Yes, he did.
Okay, and did you take it back on May 20th?
No, I did not.
Okay, and so if you had the car from May 14th until May 21st, that means the vehicle was in your possession for about 8 days. Is that correct?
Yes.
Okay. And so then you decided to take the motor vehicle back on the early morning of May 22nd, 2022, right?
Yes.
Okay, and that's after you are saying that you and Harold were at the Two Taverns or Two Rivers Tavern?
Yes.
Okay, and so if I'm understanding correctly, while you were at your employment at Circle K, you took one break to go buy one bottle of brandy, is that correct?
No, I had taken 2 breaks and gotten 2.
I'm gonna get there, but, okay, so you leave and go get one, you take one break and go get it,
Yes.
one bottle, right?
Yes.
And then you leave again and go get another bottle, right?
Yes, ma'am.
And so it's your testimony that you were drinking these 2, it was brandy bottles, right?
Yes.
Okay, out of a Circle K styrofoam cup.
Yes.
Okay, and so then after that, you get in your motor vehicle and you go drop Maria off, is that correct?
Yes, ma'am.
And then after you drop Maria off, you go and you're in the parking lot, of the Circle K located by the Motel 6, is that right?
Yes, it was at the intersection of O'Connor and Asbaugh, I believe.
Okay, and so then after you're there for a while, is that when you're saying you went to Harold's, motel?
After I had gotten the beers, I was in the parking lot for a while. Yes, I was.
Okay. I forgot that. Okay, so while you were in the parking lot, you obtained the 2 Dos Equis beers. And then you consumed both of those before going to Harold's?
I believe I opened one of them up, but no, I didn't finish.
Okay, so then when did you drink the rest of them?
Yeah, in Harold's motel.
Okay, and then while you're in Harold's motel with him, is he drinking as well?
No, he wasn't drinking at his motel.
Okay, but y'all are both smoking marijuana.
Yes.
Okay, and so then at this point, how would you rate your intoxication on a scale from 1 to 10?
Objection calls for speculation.
It's-
Overrule.
I can't really recall. That was many years ago, and by the alcohol, the intoxication that I did get that night blurs my memory. I'm unable to recall.
Okay. And so after you consume the 2 beers and smoke the marijuana with Harold there, that's when y'all decide to go to the Two River Taverns.
Yes, he mentioned to me that last call was going to be soon.
Okay, and so then you guys get to Two Rivers, and then how many drinks did you consume there?
I cannot remember. It was a lot.
Okay, well, do you remember what you were drinking?
Yes, it was Romans.
Okay, and so yesterday so you're saying that you can't recall the exact number of drinks that you had?
Not the exact number, but I could give an estimation if you like.
Well, I don't want you to speculate, so we'll just move on. So then, what's going on while y'all are at the Two Rivers Tavern? What are you and Harold doing?
We're actually talking to the bartender. The bartender was going from just serving people at the bar, having conversations with them.
Okay, and were you having conversations with the bartender?
Yes, I was.
What were y'all talking about?
I can't remember, but I know we were laughing.
Okay, and were you and Harold having conversations at this time?
He was a part of the conversation, but I don't think he was adding much to it. No.
Okay. And then so after y'all are done there, then you decide to go drop off your dad's motor vehicle at the Buckmore residence, right?
Yes.
Okay. And
So it's your testimony that you were, I mean, at Two Rivers, would you be able to rate yourself on a scale of how intoxicated you were after leaving Two Rivers?
No,
And why is that?
because I can't recall. It was too long of a time ago, about 3 years, 3 years ago.
Okay, and then earlier you said that your intoxication adds to your lapse in memory.
Yes, as well as the time.
Okay. And so when you leave the Two Rivers Tavern, are you driving down O'Connor Road?
Yes, I am driving north on O'Connor.
And so yesterday it was your testimony that you, while on O'Connor Road, you had this impulsive idea to shoot the firearm.
Yes, that is correct.
Okay. And you would agree with me, it wasn't that impulsive because you texted Tatiana at 1:34, shoot out tonight, right?
I would not agree with you. That was an emotional manipulation tactic on my part. I was trying to get her to answer. I was calling her phone frequently and she was not answering the phone, but I knew she was asleep. I would do things like that, say that I got into a car accident or things like that to try to get her to answer.
Okay. Well, let's take a look at that. So I'm going to show you State's Exhibit number 122. Can you take a look at this for me?
Yes.
Okay. Does that appear to be a fair and accurate depiction of you and Tatiana's text messages that night?
Yes.
Okay, and so if we look at the State's Exhibit, your messages are in the green and Tatiana's messages are in the blue, right?
Yeah.
Okay, and so if I start counting from 1:37 a.m., Tatiana texts you 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14 times before you respond to her. Is that fair to say?
Yes.
Okay. And then you respond to her one time and then she texts you 1, 2, 3, 4, 5, 6 times, going to 1:33 a.m. Is that fair to say?
Yes, she
And
was
then-
very angry.
Okay. And then you are communicating with her at 1:33. And then Tatiana texts you at 1:33 a.m. 1, 2, 3 times, correct?
Yes.
Okay. And then at 1:34, you text her something back, correct?
Yes.
And then she texts you a message at 1:34 a.m., correct?
Yes.
And then your response to her was shoot out tonight, please fuck.
Yes, she was very angry and not answering her phone calls. I was trying to get her to pick up the phone and also trying to get her to be more worried about me and not as angry at me for not being home, if that makes sense.
Okay, but in these text messages, she's telling you that you need to get home. And in your interview with Detective Tudor, you said that your phone was only able to send text messages. Do you recall that?
I don't remember, no.
Okay. And then
Will you go ahead out and look at State's Exhibit 124 for me? Does that appear to be a fair and accurate depiction of the text message that you sent Tatiana?
Yes.
At this time, the state offers State's Exhibit 124 into evidence and tenders to defense for inspection.
Can I approach Judge?
Yes. Just a moment. Number 124 is admitted.
And so you would agree with me that the word or shootout, the meaning of that is gunfire exchange between two people, right?
Yes.
Right, okay. And so that was a text that was sent by you at 1:34 AM. So that's approximately 30 minutes before the shooting that we're here for today, right?
Yes.
And so you're leaving the Two River Taverns and going down O'Connor, right?
Yes.
And you had your headlights on, correct?
Yes, I can remember.
You said you do remember?
If I could remember correctly, yes.
So I'm gonna ask you to watch this video that's been entered into evidence. If you can't see it on the screen directly in front of you, feel free to look at the big one behind you, okay? Okay, and so we can see headlights illuminating O'Connor Road right there, right?
I can't really see that well.
Do you want to step down or?
It's my eyes. It doesn't matter where I step, it's gonna give me a hard time. I'm not gonna be able to see it. I don't see any headlights. No, I don't.
Okay, how about now? Just stand right there and I'm gonna replay it for you. Okay, so you see how it's dark right there, right?
Yes.
Okay. Okay, now can you see light illuminating on Connor Road?
Yes.
Okay, and that would be your motor vehicle that you were driving on 5/22/22, right?
Yes.
All right. And so we see you make this left turn into the parking lot. And your vehicle kind of slows if you look at the state exhibit.
Yes.
Okay. So your vehicle kind of slows down right there, right? Okay, is that the point where you were testifying yesterday that you were taking the motor vehicle or the handgun out?
Then I testified that I was charging the handgun, yes.
And by charging, you mean
Yes,
knocking it?
I was looking down into my lap, yes,
Okay.
charging.
And so at what point did you say that you slowed down to take the handgun out of your waistband?
I was pulling it out and I looked down. That's why I was slowing down on the turn, because I looked up and thought that it was my turn.
Okay, so right here is where you're slowing down, taking the firearm out and.
I would say I took it out a little bit beforehand, and when I'm slowing down is when I'm looking down, trying to mess with it, charge it.
And so your headlights are on, we see that clearly in the state's exhibit, right?
Yes,
Okay, and at this point, when you straighten out, you would have a clear view of the parking lot, right?
yes,
Okay. And if you look at the state's exhibit, can you tell me what this is right here?
that is a parking lot light.
Okay, and what about right here?
I don't see where your cursor is, but I'm sure it's a light. There it is, yes.
And then right here,
Another light,
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 and then right here.
another light.
And then there's also some lights in the carport over here, right?
Yes,
And then lights affixed to the building to immediately to the left of the police vehicle, right?
I can't see them. I'm not too sure. I'm pretty sure if you're saying they're there, I believe you.
Okay. And so then at this moment, after you pull your firearm out and rack it, you accelerate on high speed, right? You accelerate on high speed?
I was already driving fast. Yes, I was just driving fast, period.
Okay, but from after slowing down, you accelerate again, right?
Other times, yes.
Okay, and then discharge the firearm, right?
I wouldn't say right there, but yes, I do discharge my firearm.
Okay, now I'm not saying right there, but I'm saying after you start accelerating, that's when you start firing, right?
Yes,
Okay. And, you heard the testimony of, Officer Hymas, correct?
yes, I did.
And, with your headlights being on, you heard testimony from multiple witnesses that the vehicle has the reflective decals on it, right?
The small SAPD on the grill guard, yes.
Okay, and then the rest of the vehicle also has reflective.
On the drive, yes.
Right?
On the
And so at some point, your headlights would have reflected off of the SAPD, right?
The tiny letters, yes.
Okay, and so you would have seen the vehicle at that point, right?
No, ma'am. I didn't see any vehicles, even the truck that was apparently parked in the handicap spot. I didn't see any vehicles in that parking lot.
And why is that?
I was very intoxicated. I have very poor eyesight, and I can't remember if I had my glasses or not.
Okay,
They
and
were
why can't
very
you
broken at
remember?
the time. They were taped halfway through the lens, so I didn't have any peripheral vision
And why can't you remember if you were wearing your glasses or not?
because I was intoxicated and it was a very long time ago.
Okay, so do you understand that? And let me just go back a little bit. So when you're drinking, this is the choice that you made, right?
Yes,
You
yes.
wanted to get intoxicated, right?
I wasn't planning on getting intoxicated. I just wanted to have a good time.
Okay, but you were the one that
Yeah,
decided to continue drinking that.
Yeah.
Basically. Nobody forced you to do
No.
that. And so you understand that voluntary intoxication is not a defense to this offense and to tax.
The objection calls for a legal conclusion from a lay witness.
All right, that objection will be sustained.
And, but it's your testimony that you can't remember a lot of the details that night because you were so intoxicated.
The minute specific details, I can remember what happened that night and what was going through my mind.
So you conveniently can remember that you didn't see vehicle there and that you didn't.
I'm saying that I wasn't blacked out,
Can you
that I
please-
can't remember things.
Can you please wait until she finishes asking the question?
Okay, so you are saying that you're so intoxicated that you can't remember if you were wearing your glasses, you can't remember what was discussed. You can't remember a lot of details, but you can conveniently remember that you didn't see any motor vehicles in the parking lot, right? You can remember that. You weren't too intoxicated to remember that.
Yes, ma'am.
Okay, and that you didn't realize that they were police officers, not too intoxicated to remember that,
Yes, ma'am.
but too intoxicated to know where you were, what you were saying, and a lot of details about what you were doing.
I knew what I was saying, I just can't tell you specific jokes that we were laughing about at the bar, ma'am.
Okay, but
I
earlier
can't
you
remember things.
said, I can't remember because I was just very intoxicated.
I also said that it's been a very long time ago. I can't remember the specific details with each and every conversation I have between people.
And you heard the testimony of Officer Hyman. Let me back up. It was your desire that night to discharge the firearm, right? That's what you wanted to do.
I wanted to go to the range. I've been expressing to my wife multiple times, not just that night, but previously, that I've been desiring to go to the range.
Okay, but you knew that you weren't at a gun range there, right?
Yes, ma'am.
And your intent that night was to discharge the firearm because according to you, you weren't gonna have a car to go to the gun range.
Yes, ma'am.
Okay, so you intentionally made the decision to rack the firearm and pop some shots off, right?
Yes.
That's what you wanted to do.
Yes, I did want to shoot my gun, that's right.
Yeah, you did. And you knew that if you're driving, even if it would have to occur the way that you say you wanted it to, which that you were traveling down Santa Gertrudis, which is a residential street, right?
Yes, it is.
That there is a big risk that there could be somebody traveling down that street, right?
Yes, ma'am.
And you disregarded that risk, didn't you?
I was very inconsiderate, yes.
Yes. Now, you heard the testimony of Officer Hines, right?
Yes.
Okay, and so his testimony was that he saw the muzzle flash about 30 to 40 feet in front of his patrol vehicle, right?
Yes, he did say that.
And you would agree with me that his perception is probably correct, right?
No, perception and perspective can be different between each and every person involved in any such scenario.
Okay, so you're saying that his perception was incorrect and
Yeah.
yours was correct?
I can tell you what I was doing and what my intent is to doing, and you can make your own perspective based on that.
I don't mean anything. I'm looking at the evidence in this case, and what the evidence suggests is that his perception is correct because he wasn't intoxicated and you were.
I'm gonna object to argumentative testifying.
All right, that objection will be sustained.
So what is your approximation of how many feet you were away from the vehicle when you decided to fire?
Objection calls for speculation.
Overruled.
I would say at least 100
So you can remember that. You weren't.
from the videos. I'm saying it in reference to the videos that I've gone over with my attorney.
Okay, and so you saw in the safety exhibit exactly where the muzzle flashes, correct?
I couldn't really make it out.
Okay, so then how can you know that you were 100 feet away? Are you relying on your memory or the video?
No, I'm relying on my attorney. We've gone over the videos and we've also taken measurements ourselves.
So your testimony is you're relying on what your attorney has told you.
Judge, I'm gonna object at this point.
That's what you just said.
Well, it goes to attorney-client privilege. She's asking about things that we've discussed at this point.
It's not confidential.
And she's continuing to ask, Judge.
All right, so everyone, if you have a seat, and you all can make your objections seated, it makes it easier for the court reporter
Sorry, Judge.
to hear.
Muscle memory. Yeah.
No problem, I understand. All right, State, you can ask that last question.
So your testimony, just one question ago, that you're relying on what your attorney told you.
No, I'm relying on the videos that I've gone over with my attorney.
The video that you just stated you couldn't see muzzle flashing.
Yes, that video.
So not your memory,
No,
because you were too intoxicated to remember exactly, right?
to remember the exactly distance and how many feet. Yes.
Okay. And Officer Hines returns fire at you, right? We've established that.
Yes. Yes.
And so you testified that you purchased this this handgun for, I guess, self-defense, right?
For work purposes, yes.
Okay, and that's because at work, somebody told you that they had a handgun when they were stealing items from the Circle K?
Yes, as well as other instances.
Okay, and did that make you feel threatened?
Yes.
Threatened enough to go purchase a firearm?
Yes.
Okay. And at this time, during your testimony, you said you didn't know who was firing at you or what was happening because you couldn't even hear really. You just felt the impact of the bullets, right?
Yes, ma'am.
And so at this time, this gun that you purchased to protect yourself, you decide
it's perfect time to just put it away.
It's the perfect time to get away. To
Okay, and so you don't return.
separate myself from whoever's trying to attack me. That's the first thing you always do is run. Don't try to fight back.
Okay, but you purchased the firearm for self-defense, right?
Yes.
Okay, and so you chose, in your head, what you're asking this jury to believe is that you believed at the time that you were being fired upon unsolicited, right?
Yes.
Okay, and you decide not to protect yourself and return fire.
Not when the option to get away was there. Yes.
Okay, and so it was your testimony yesterday that you didn't realize where you were until you came off of the drop off from Bucharest to Higgins, right?
Yes, ma'am.
Okay, but if we look at. I'm just thinking. Okay, can you see that?
Yes, ma'am.
Okay, so if we look at defendant's exhibit number 1. Sandra Bertrudis is 2 streets over from the church, correct? 1,
Yes,
2.
yes, ma'am.
Okay, and Sandra Bertrudis is a street that goes straight through to Higgins, you said, right?
Yes, ma'am.
Okay, and so. How, you said that you lived in that area of town since you were 7 years old, right?
Yes, I have.
So you're pretty familiar with the area, right?
Yes.
Okay, and so you would have realized that when you get to this curve right here, that you're not really where you think you are, right?
That's not when I realized.
You would have realized, right?
No, more than I would have realized. I did not realize where I
Okay,
was.
so why did you not realize that if you know that Sandra Bertrudis is a straight street and you're clearly curving?
I had just been shot at and I was under very stressful circumstances. I was also intoxicated.
Okay, so too intoxicated to realize where you were at that point.
At that point in time, yes, ma'am.
And so then you get onto Bucharest and then go off the drop off, right?
Yes.
And then you said that you unloaded your gun. At what point in time did you do this?
I did it whenever I made it back to my parents' house.
Okay. And you said that you did this because you didn't want to get a gun exchange with anyone?
That's correct.
Okay, and so then when did you reload the vehicle? Or the pistol, because you're aware that the CSI found it loaded with a one in the chamber, right?
Yes, ma'am. I unloaded it with the clip out, so the clips still stay loaded. And then I took the bullet out and put it onto the floor. And then I put the magazine back in. The magazine had stayed loaded. And then once the morning had came, I believe I had wrapped one and put one in the chamber because that's how I carried it on my person.
Okay. And then if we talk about Sandra Bertrudis, right? And we see here, it's a residential street, right?
Yes.
Okay, so I'm showing you defendant's exhibit number 81. Which you testified or is a fair and accurate depiction of revocation. And then state exhibit number 82. I mean defendant's exhibit, excuse me. And then defendant's exhibit number 83. Do you see any lights or light poles in this exhibit?
No, I do not.
What about in defendant's exhibit number 84?
No, it's also not nighttime, so I wouldn't be able to see them.
What about defendants exhibit 85?
No, it's also not nighttime.
These are your exhibits, so
Yes.
you can tell me what you are viewing in the exhibit currently, okay?
Okay,
Do you see a light pole in defendant's exhibit number 86?
yes, I do.
Are there lights on it, or is it a utility pole?
It looks like there's lights on it.
And what about the utility poles in defendant's exhibit number 87?
What about them?
Do you see lights on poles?
No, ma'am.
And what about in defendant's exhibit number 88?
I'm not sure if that's a pole with a light on it. It's daytime, but it could be. But other than that, no, I see no lights.
Okay. And so Santa Gertrudis at nighttime traveling down, it would have been a substantially darker area than the church parking lot where you turn down, right? Because there's no
I wouldn't
lights.
say any more substantially. It was nighttime. It was just dark.
How would it not be substantially if there are no lights on Santa Gertrudis Street and there's ambient parking lighting?
Objection, facts and evidence, Judge. Mr. Ashbaugh stated he thought he saw some lights and wasn't sure. And so the prosecution is just entering facts. That's her own opinion.
Oh, overruled.
It was just nighttime, and my vision is really poor. The astigmatism affects it specifically at night.
Okay, well, that's interesting because astigmatism actually makes objects appear brighter than they are, right?
No, ma'am, they give you glare in your vision when it comes to lights.
May I approach, Judge?
What are y'all approaching for?
Okay, can you take a look at State's Exhibit number 25 for me?
Yes.
Okay, and is this a fair and accurate depiction of normal vision?
Yes.
And is this a fair and accurate depiction of how you would see with astigmatism as you've explained it makes the glare?
Astigmatism is the curvature of the eye, so all of them are different, but yes, it is an accurate depiction.
Okay, so you would see the lights like this, like,
Glare, yes.
okay. At this time, the state offers State's Exhibit number 125.
No objection.
All right, State's Exhibit number 125 is admitted.
Okay, and so if we look at the right side of State's Exhibit number 125, that is what somebody with normal vision would see, correct?
Yes.
But if you look at the left side regarding the astigmatism, lights are glared, right?
Yes, lights are glare.
Okay, and so that's what you're saying that you see at night, glaring lights,
Yes.
but just not in the parking
Just
lot.
difficulty seeing in general during the dark.
But so you would see glared lights, but just not in the parking lot of the church, right? That's what you're asking the
I
jury to
didn't
believe.
see lights. I didn't see any vehicles.
Well, why didn't you see the vehicle?
I've told you I was intoxicated. I didn't have my glasses, or that I can remember. I could not see anyone in that parking lot.
Now, looking at defendant's exhibit number 1, okay. If you look right here on Santa Gertrudis, there's 2 church buildings, correct?
Yes, ma'am.
Okay, and then immediately after that is kids playground, right?
Yes, ma'am.
Okay, and then after that is another building, right?
Yes, ma'am.
Okay, and then when the open field starts, that open field is actually captured by metal fencing, right?
Not that I know of.
This right here. And defendant's exhibit number 87,
what does that appear to be to you? There's metal fencing
Fencing.
here and here, right?
Yes,
Okay, and the playground is located behind here, right?
I believe so.
Okay, and so even if you were traveling down, or if it was how you asked the jury to believe you, that you believe that you're traveling down Santa Cruz, there's a risk that you would have fired into the church building, right?
No, ma'am,
How not?
because I was shooting into the ground. You shoot into the ground, it's not gonna hit a building or anything on the sides. When it goes into the ground, it just goes into the ground and bounces off.
Okay, so you're aware that bullets can ricochet, right?
Yes,
So there's no way that you can guarantee to this jury that the bullet is not going to hit something, right?
No, I
Cause
can't.
you don't know that, do you?
No, I do not.
And Judge, I would just ask that the witness be given a chance to respond before he's being talked over.
All right, so parties, just make sure you wait for the question to be finished, then you can answer and wait for the answer. Right.
So there's a risk that you disregarded, that you could have fired into the church, right?
It's very considerate of me, yes.
If there's a risk that you could have fired into the playground, right?
Yes,
And you would agree with me, that's very inconsiderate to have Sunday school children picking up shell casings, right?
yes,
And then there's a risk that even if you would have fired into the open field like you say you intended to, that the bullet could have ricocheted off that metal fence and hit anyone, right?
no, the fence is above the ground. I was shooting into the ground, making sure that it was going to hit the ground.
And like we've previously discussed, right? Bullets can ricochet off the ground, right?
Yes,
Okay, so when you fire that pistol,
yes.
you have no idea where the shell's gonna go.
No, I don't control that.
Okay. Now, then it's your testimony that you gained your bearings again when you hit the drop off from Viewcrest to Higgins, right?
I realized where I was.
Okay, and so you come to this realization, right? You're able to drive to your father's house without incident, right?
Yes,
And so earlier you said that you didn't want to go to your apartment with Tatiana because you had concerns about their safety, right?
yes.
But you didn't share those same concerns about your father or his residence, did you?
No, I did share those same concerns.
Okay, but you still went and left the vehicle there with evidence, right?
Yes.
Okay, and you didn't let him know that you dropped it off, did you?
No, I didn't. It was 2 o'clock in the morning.
Okay, and you leave it there. And you're able to park it straight in the driveway, right?
My boat parked in the driveway, yes.
Okay, well, you saw the video, that was parked correctly, right?
Yes.
Okay, you didn't crash into the house or anything.
No, I didn't crash into the garage.
Okay. And then Harold picks you up.
Yes.
Okay, and so you choose not to call the police, right?
Yes.
And then Harold tells you that you should call the police and you refuse, right?
He never told me that.
Okay, so you're saying that he's a liar.
Yes.
Okay. And he's also, so I guess which parts are truth and which parts are lies from Harold?
Judge, that question is just too general to answer. If she has a specific question, I'd ask her to ask that, but just
Right. The objection will be overruled.
You can go ahead and answer.
The part where he said that he told me to call the police. He never told me to call the police. And also the part where he said we didn't go to the bar in his interview. We did go to the bar in the interview. And also the part where he said that we didn't go to his hotel room in the interview. We also went up to his hotel room in the interview.
Okay, and you watched his interview with your attorney?
Yes.
Okay, and so I guess now you're saying everything that he testified to on the stand is true, but for the fact that he told you to call the cops.
I can't attest to whether his testimony was true or not.
Well, didn't you just say he was a liar?
Yes, I did say that.
Okay, so then you can attest because you just did.
And Judge, I'm
didn't you?
gonna object to argumentative.
Right, that'll be sustained.
Now, did you have an opportunity to talk to Harold before, you all ended up at SCPD headquarters?
No.
Okay, and so Harold is actually texting you
between the time that he dropped you off and the time that you're arrested on the 22nd, correct?
Yes,
And he's asking you to provide details about what happened, and you refused to do that over text, right?
no, I specifically told him I did not shoot at the fucking cops.
Okay, but when he's asking you what happened,
I
you're
told him I
telling
didn't
him,
shoot at the cops.
but then you tell him that he needs to go to your home, correct? That you don't want to talk to him over.
I told him to come over and talk. Yes, I did.
Okay, and then you also told him to bring weed with him, right?
Yes, yes, ma'am.
Okay, and because you smoked weed in your apartment at that time?
Not inside my apartment, no, but yes, I did smoke weed at that time.
Okay, so would it surprise you that Officer Christensen said that when you went in the apartment it smelled heavily like marijuana?
No, that would not surprise me.
Okay, because you would smoke inside,
Objection asked and answered.
Overruled.
why would it smell like marijuana inside the apartment if you don't smoke inside the apartment?
Because it's just a smelly substance. I myself would smoke and then my clothes would be inside, the smell would be on my clothes.
Would you keep marijuana in the apartment?
No, not in the apartment.
Okay, so you're saying that just your clothes is what would steam up the whole apartment smelling of marijuana?
Yes, yes, ma'am.
Then, I guess before Harold gets there, you asked Tatiana to lie about your whereabouts that night, right?
I asked her to say that I was there at the apartment, yes, which she told me she wasn't gonna do, and I dropped it. I said in a state of hysteria when I woke up and she first told me about the news articles. I was crying, I was just very hysterical.
Okay, and so you asked her to make an untruthful statement to police about your whereabouts, right?
Yes, I did.
Because you, in fact, were not with her that night, right?
No, I was not with her.
But that's what you asked her to tell police.
Yes, I did.
And so Harold gets to the apartment and you're not able to see him before you all get your statements, correct?
Correct.
Because you're taken into custody and then he's taken downtown as a witness, right?
Yes, yes, ma'am.
And then you get downtown with Detective Tudor and you just tell him something wholly different than what you testified to yesterday. You would agree with me, right?
Yes, I would agree.
So let's talk about that. So starting off, you told Detective Tudor that you dropped the motor vehicle off at your father's house first and then went to the tavern, right?
Yes, I did say that.
But now you're asking the jury to believe that you went to the tavern and then dropped the vehicle off.
I'm not asking them to believe based on the fact. I believe they can conclude their own opinion.
Okay, but that's not what you told Detective Tudor, right?
No.
So that was a lie, right?
Yes, that was a lie.
Then Detective Tudor asked you about being shot at and you denied to Detective Tudor that you were ever shot at, right?
Yes.
And you say you don't know what happened to the motor vehicle, right?
Yes.
Okay, and you told Detective Tudor when you dropped it off, it was good, right?
Yes.
And Detective Tudor specifically asked you about your level of intoxication. And you said you were pretty fucked up, but not sloshed. Do you recall that?
Yes, I do.
Okay, but now you're saying that you were heavily intoxicated to the level of slosh?
Yes.
Okay, so that was a lie.
Yes, it was.
All right. You told Detective Tudor you have no idea why the motor vehicle would be parked at your parents' house with damage, is that correct?
That is correct.
Okay, you told Detective Tudor that you did not tell Harold that you were shot at, right?
Yes.
But yesterday you testified that you did tell Harold that you were shot at, right?
Yes.
And so when Harold was telling Detective Tudor or Detective Martinez that you said you were shot at on a corner road, that would have been a true statement at the time, right?
No, I didn't give any location. All I told them was that I was shot at.
Okay. You told Detective Tudor that you had never shot your firearm. Is that correct?
That is correct.
You have told Detective Tudor you had no clue why there would be shell casings in the Nissan Rogue.
Yes, that is correct.
And then you go the extra mile to make Detective Tudor believe that you're being honest with him, right? Because you tell him, what
No, he says multiple times that there's something missing there. He knew I wasn't being honest with him.
okay, but you're trying to sell your story to him, you would agree with me, right?
Yes.
Right, and you tell him, let me tell you something about honesty. You can't get caught for it.
You told him that, right?
Yes,
And you have been caught for your dishonesty. Would you agree with me?
yes, all dishonesty gets caught.
Okay. And you told Detective Tudor, that you reiterate again, you've never fired that 9mm cannon, right?
Yes,
Okay. You tell him that the ballistics are going to prove what you've been telling him during the interview, which was that the gun was not used in any shooting, right?
I was trying really hard to talk my way out of the situation, yes.
Okay, you told Detective Tudor that you wouldn't even be in this situation if it wasn't for your father asking for your motor vehicle back.
I can't recall saying that, but that does sound something like I would say back then.
Okay. You told Detective Tudor that you did not tell anyone that you got shot, right?
Yes,
Okay, and then you changed your story about halfway into the interview to you heard a shooting in the area, right?
yes,
Okay, and then you didn't get hit though, right?
yes,
Okay, and you heard only one shot, that's what you told him, right?
yes,
And you reiterate again, you don't know why there would be spent shell casings in the motor vehicle. Right?
yes,
Okay, and then he asked you if stuff got sideways and you swear to him nothing got sideways last night, right?
yes,
Okay, and then you again deny shooting the gun the night before. Right?
yes,
Okay, and then you tell him that you aren't aware of anyone shooting at you, right?
yes,
Okay, and then you continue to tell him you don't know why the car would be on video in the church parking lot, right?
yes,
Okay, and then Detective Tudor built your defense end for you because he specifically asked you during the interview, is it possible that you didn't know that they were cops? And do you recall what you said?
no, no,
Okay, you said, I don't know.
And Judge, I'm gonna object to that. That's a statement, not a question.
All right, if you'll ask the question, please.
And I'm gonna object to hearsay.
Oh, that will be overruled.
I asked you all what you said. Yeah.
All right, if you'll just re-ask that question, please.
So you don't recall what you told him?
I don't recall him saying that to me.
Okay, so when he told you, maybe you didn't know they were police, you don't recall telling him, I don't know.
I remember him asking me, saying that maybe these police officers messed up somewhere and me still not saying anything. I remember that.
Okay, and so you understand that had things occurred how you were purporting them to, that you were just unsolicitably fired upon, these police officers could have gotten in serious trouble.
Yes, I understand that.
Okay, but you didn't care, right? Because you just wanted to get to work that day, right?
I wanted to provide for my family, yes, but I did not care at the time.
Yeah.
I was very inconsiderate, yes, ma'am.
You wanted to provide for your family at the expense of everybody else.
No,
How not?
I was just struggling as a young father and needed help.
Okay, and so you didn't care about what would happen to anybody else in that time, just you and your family, right?
No, it's not that I didn't care about anyone. I was just very impulsive, very quick, didn't really have a lot of thinking in between my thoughts and my actions.
Okay. And so if Detective Tudor asked you, maybe you didn't know they were cops, when did you decide to go along with this as a defense?
Judge, I'm gonna object. It goes into possibly attorney-client privilege.
Yeah.
All right, if parties can approach.
Okay, so when did you decide to change your story from you don't know what happens to you didn't know they were police officers?
I didn't change the story, man. It is just the truth of what happened that night.
So you didn't change the story from what you told Detective Tudor until what you're testifying to now? It hasn't changed?
Yes, I was lying, but now I'm telling you the truth.
Okay, so you're asking this jury to believe you now.
Yes, sir.
What made you decide to tell the truth now? Is it that we have your fingerprints, DNA, and video evidence of you that you decided that you needed to tell the truth now?
No, ma'am, it's actually because I gave my life to Jesus and I've changed since my son's been born.
And when was that, last year?
Sure.
Now, you told Detective Tudor, that you heard the shooting and then went to your father's house, right?
Yes.
But then you changed your story and then you say you heard the shooting on the way to your father's house, right?
Yes, I did say that.
Because we're both like. And then you told Detective Tudor that the ballistics were gonna show that you're innocent, right?
Yes, I did say that.
But they didn't show that, did they?
I'm gonna object that that calls for a legal conclusion, Judge. Asking him to say if a specific piece of evidence says if he's innocent or not.
All right, that'll be sustained.
Now, yesterday you described yourself when you dreamed as, how did you describe it? As you get kind of obnoxious?
Yes, obnoxious.
Okay. And what other words did you use to describe it?
Giddy, uplifted.
Would it surprise you that Tatiana said that when you drink that you get more assertive and that she would believe you to be capable of doing something like that?
Judge, may we approach?
Yes.
Would it surprise you to know that Tatiana used different descriptors of you when you're intoxicated?
No, that wouldn't surprise me.
Okay. And now, you've had a prior interaction with Officer Hyman, correct?
Judge, may we approach?
Yes. All right, States, you may proceed.
Prior to the night of the shooting, you had had a previous interaction with Officer Hymas, correct?
I was made aware that I had one, but one that I can recall, no, not that I remember in my memory. I could not tell you when or where or how I interacted with Officer Hymas on what day or anything.
All right. Ladies and gentlemen, we're going to take a 10-minute break and we'll have you all come back. Remember my previous release.
All right, so you're.
All right, States, you may proceed.
Thank you, Judge. Now, Mr. Ashbaugh, I mean, you testified that you were extremely intoxicated on the night of the incident, correct?
Yes.
And at the time that you gave your statement to Detective Tudor, it's fair to say that the scientific evidence had not been analyzed yet, right?
Yes.
Okay, so at that time that you gave the statement, the fingerprints hadn't been analyzed, right?
Yes.
The DNA hadn't been analyzed, correct?
Correct.
All of the video hadn't been obtained, correct?
Correct.
And the shell casing hadn't been sent to the lab, right?
Correct.
And so you wait until almost 3 years later to come forward and tell the truth about what happened that night, right?
Under the advice of my attorney, I was not to speak to anyone about the case.
Okay, and so you never decided to, you know, let Detective Tudor know what happened that night or your rendition of it, correct?
Correct. Under the advice of my attorney.
And, but now you're asking the jury to believe your testimony because now you're telling the truth, right?
I am telling the truth, yes.
Yeah, even though you were extremely intoxicated, would you say that your memory of it was better after it happened or now?
I would say as I have dug deeper into trying to remember the night, it has gotten a little bit more clear.
Okay,
But as time has gone on, it's also been a significant amount of time between that night and today. So it is harder to recall some things.
okay, and that's because of the time and also your level of intoxication, right?
Yes, ma'am.
Now,
I'm gonna show you what has been marked as State's Exhibits 126 and 127. Can you take a look at those for me, please?
Yes.
Okay. Do these appear to be fair and accurate depictions of text messages that you sent on May 22nd of 2022?
Yes.
Okay. And so at this time, I'm tendering to defense for inspection and offering State's Exhibits 126 and 127 into evidence.
Judge, I'm gonna object to 127 for relevance, and then 126 under optional completeness, cherry
right.
picking a single text.
If I could
different
see
texts.
the exhibits, please.
Take a look at State's Exhibit number 126. It appears at 5:22 on 5/22/22 at 11:12 a.m. You texted Harold Clemens, "I'm going to jail," correct?
Yes.
But it's now your testimony that you came to believe that just after reviewing a news article that Tatiana showed you.
Repeat the question.
I said, you're asking this jury to believe that you texted that after reviewing a news article in which Tatiana showed you.
I'm sorry, I'm kind of confused by the question.
Okay. You texted Harold Clemens on 5/22/2022 at 11 a.m. So that's after he dropped you off at 7 a.m., right?
Yes.
You texted him, "I'm going to jail."
Yes, I did text him that.
Okay. But on your direct examination, you stated that you only texted him that because you reviewed a news article of what happened, right?
Yes, my wife shows me a news article.
Okay, and so that's your testimony that that's what made you believe that you were going to jail.
That's what made me text him that, yes.
Okay, and then if we look at State's Exhibit number 127, you text a person saved in your phone as LJ on 5/22/2022 at 11:45 a.m. Can you go ahead and read that for me, what it says?
Bro got into some shit, beat up at the store.
Okay. And so you're letting that person know that some events had occurred last night, correct?
Yes, I was trying to meet him at my store for whatever reason.
Okay. Was it delayed, I guess, because at this time SUPD was running surveillance on you?
Yes.
Okay. Now, during the break, you refreshed your memory. Have you had a prior interaction with Officer Philip Hines?
After refreshing my memory, yes. I have.
Off the witness from.
All right, defense, you may proceed.
Thank you, Judge. Good afternoon, Tyler.
Hello.
So during your testimony with the state, they asked you to estimate some distances between where you believe you fired the weapon and where the police car was, correct?
Correct.
Those estimates, are those estimates that you're discussing after you've reviewed the video or estimates from something else?
After I've reviewed the video.
Okay. That, and your testimony has been that you did not see any police officers, correct?
No, I saw no police officers, no lights, nothing of the sort.
No people?
No people either, no.
You didn't see their car, you didn't know it was there?
I did not see their car at all.
So it was estimating any distance from you to anything in your mind on that night?
It's impossible.
Okay. And now I'm gonna, if you'll give me a second. I'll show you what's been entered into evidence as defendants exhibit 79 and 80. Do you recognize these photocopies?
Yes.
What are they?
My Torah license.
Okay. Do you have your wallet on you right now?
Yes, I do.
Could you pull it out? Can you hold it up and show that to the jury?
I'm gonna object as to facts not in the evidence, relevant, and referring to an item that's not in evidence.
All right. With regards to referring to an item not in evidence, that will be sustained.
Okay. What did you pull out of your wallet, Tyler?
My driver's license.
Is it the same license that's in defendants exhibit 79 and 80 that's been photocopied?
Yes.
Okay. What's the state of your license?
It is falling apart, broken in pieces and taped together.
Okay. So it's taped together.
I'm missing my name.
Okay. And now you described that your glasses at times would be broken as well. Is that correct?
Yes.
Okay. Would you try to fix it the same way with tape?
Yes, duct tape or even clear Scotch tape like this.
In fact, sometimes when you had court dates here, you would come with duct tape on your glasses.
Yes.
Excuse me, when an objection is made, do not answer. I will make a ruling on the objection. All right, what is your objection?
Relevance.
Sustain.
Okay. So is this your license, Tyler?
Yes, it
It's
is.
the same one here.
Yes.
Okay, Judge, I would tender this license to the state for inspection and offer it into evidence.
No objection. Are you gonna put a number in?
All right, could I have parties approach, please? I think defense, you're on,
82.
no, you already have
81.
an 80, it would be, unless it's been pre-marked, defense, I believe you're on exhibit 92 would be your next exhibit number.
It would be 92?
Yes.
Okay.
Defense exhibit 82 is another exhibit. Um, I'm just trying to make sure the exhibit doesn't get lost. And if there's another way to mark it, but if there isn't. Would you like to put the exhibit number there? Because otherwise it'll get lost. Okay. Thank you.
So it's admitted, Judge?
Yes, but he hasn't given me the number yet. Probably if you put it on the black strip.
That's what I did, Judge.
All right.
Okay, I'm gonna offer defendant's exhibit 92 in evidence.
No objection.
All right, defense exhibit number 92 is admitted without objection.
Okay, Tyler. Now we see on the front of your license, you have a restriction. What does that say?
Yes, it's. Midday.
Class. Look at the front and just tell us what the restriction
Class
is.
A restriction.
Okay. And now on the back, does it have an A marked and say what that correlates to?
Yes, it says with corrected lenses, you're not allowed to drive that way.
Okay. Oh. Okay, Tyler. Now, one of the state's exhibit was admitted into evidence, which was a text that you sent Harold, correct?
Yes.
Okay. Was that the last text you sent Harold before you were arrested?
No.
What was one of the last texts that you sent Harold before you were actually arrested?
I told him I didn't shoot at the fucking cops.
Okay, so when you so the exhibit that was admitted previously that says I'm going to jail,
Yes.
is that an admission that you shot at the cops?
No, not at all whatsoever.
Is it just you realizing that you're a suspect now?
I'm not
Yes, it is.
Just once, excuse me, once an objection is raised, you need to stop talking. What is your objection? Sustained.
Okay. Describe the circumstances around that text and why you sent that.
I was explaining, in light of everything, I knew that I was a suspect. I did not think I was in the area at the time at all, so I didn't see how it could be me. But I did know that I was going to be talked to, taken in some way, shape, form, or other.
Okay. Because you knew that you had fired your firearm at some point that night.
Yes.
and somebody fired back at you.
Yes,
And then you started looking at the news article and trying to piece it all together.
yes, it was very frightening.
Okay. Now, Tyler, you heard Officer Hyman's testify.
Yes, I did.
You heard Officer Acuna testify.
Yes.
What would you say to them after all this has transpired?
I'm gonna object as to relevance.
Sustain.
Tyler, did you try to shoot anyone that night?
Objection, that's.
No, I didn't try to shoot.
Excuse me. When an objection is raised, you need to stop speaking. All right. What is your objection?
Answered.
That will be sustained.
We'll pass the witness.
All right. Any recross?
Where's that? ID.
It's clipped onto the very bottom of the defendant's exhibits.
Okay, so if we look at defendant's exhibit 92, is that the only license that you have in your possession?
Yes, sir.
Okay, what's the expiration date on this?
1/19/2025.
Okay, and so you've been operating a motor vehicle without a valid license,
Yes, ma'am.
and that's after giving your life to Jesus and changing?
Objection. Relevance.
And what's the objection? And I'm sorry, you need to, once an objection is raised by either party, just stop talking.
Relevance and asked and answered, Judge.
All right, with regards to asked and answered, that will be overruled. With regards to relevancy, that will be overruled.
Now, Mr. Navy just asked you about the text where you text Harold, "I'm going to jail."
Can you hear me?
Yes, ma'am.
Okay, so he just asked you about the text that you and Harold stating, "I'm going to jail." You recall that?
Yes, sir.
Okay, so you said that based on the news article, or you said that you came to that realization because you knew that you were a suspect at that time, correct?
Yes,
And because you knew that you fired your firearm the night before, right?
because the detectives were texting me and blowing up my phone that morning as well, trying to get a hold of me.
But the detectives didn't tell you any facts about the case, right?
No, but them just reaching out and contacting me was enough for me to know that they would need to speak with me in person.
Okay, and so that in conjunction with the fact that
Case exhibit number 99. Okay, this is your firearm, right?
Yes, sir.
And so in conjunction with the fact that the officers were texting you, asking you if you were okay. And in conjunction with the fact that you stated that you racked the gun and popped some shots off, you knew that you were a suspect in the shooting, right?
I knew I was a suspect based on the text messages from the detectives.
That in
And my parents-
conjunction,
and my parents all.
and that in conjunction with your actions that you knew you committed that night, right?
No, mostly from the phone calls from my family and my extended family and also the detective.
So your extended family and everyone knew about what you did that night?
No, they were just calling me, asking me what's happening, what had happened, which made me know that somebody was contacting them, asking for my information, which led me to believe that I was the suspect.
okay, so at the time, you're saying that you didn't have the mental wherewithal to put two and two together, that you firing your firearm that night may have landed you in some trouble. That's your testimony today.
Yes,
Okay, so you're just thinking your shooting had no relation to why the police wanted to speak with you.
I didn't think, no, my mental capacity was not at that time. No, it was not.
Okay, and so if things were really how you are purporting you believe them to be, right?
You're saying that you did nothing wrong that night.
That's not what I'm saying at all, ma'am.
But how do you just shot into an open field, right? And nobody was hit? We wouldn't be here today, right?
Doesn't mean it was a good or right thing to do. I still regret my actions.
Right, but if you did not commit a criminal offense.
That would still be a criminal offense.
And Judge, I'm gonna object that it calls for a legal conclusion from a lay witness.
Well, if I didn't
All right.
finish my question.
I mean, she's already asked that question.
All right, the objection will be overruled. You can ask the question.
If things were truly how you believed them to be, right, and you didn't fire at anyone, why not tell Detective Tudor that?
I was scared. I
Why
was
were you
scared
scared?
because I was the one that was providing for my family and I didn't want that to be taken away. I didn't want to have to go to jail and lose my job and disappoint my father and my family yet again.
Okay, well, regarding disappointing your father, I mean, you had already ticked off a lot of boxes there, right?
Yes, ma'am.
Okay, because you told him you weren't smoking weed still, and that was a lie, right?
Yes, ma'am.
And you're not going to visit him when he's asking you to do so, right?
Visit him.
At his home and the text messages when he's telling you he wants to see your daughter Davina?
I'm visiting him. My daughter is not visiting him.
Okay, do you recall in the text messages where he's asking you to stay for a little bit longer other than just dropping your watch?
Objection hearsay. The question contains hearsay.
Is it what the defendant is saying?
No, it's not.
It's not, but he opened the door as to what his father was saying.
All right, that'll be sustained.
So if he's asking to see your daughter and you're not taking your daughter over there, right?
Yes, I had moved out and had taken my family elsewhere.
Okay, and then at this time too, you heard him testify that he wanted you to get a better job with better benefits and better pay, right?
Yes, he's always telling me that.
Okay. And so if you truly in your head had not linked to the fact that your shooting was linked to a police investigation, why were you scared?
Because I knew I was a suspect. Because again, the detectives were calling me, my parents were calling me, my in-laws were calling me, they were texting me. I knew I was a subject of interest.
Regarding what?
Regarding the news articles that I was shown.
And what was in the news articles? Because there were no specific facts stated. Your family at that point didn't know the specific facts of what happened, right?
Yes, and the articles also said very different things. There were multiple ones that came out.
Okay, and so it's still your testimony at this time, you're just not putting two and two together.
Yes, that is my testimony. I was not putting two and two together.
And that's because why?
It was a traumatic event for me. I knew I was in trouble. I knew something happened, but my brain was just manic. It was just going all over the place. I was hysterical, crying. I knew I was in a lot of trouble.
Okay, and so you watched the interview that you gave with Detective Tudor, right?
Yes.
Okay, and in that video, you seem pretty calm, cool, and collected in the video interview, right?
Yes, I was still intoxicated.
You're joking with him, you're calling him brother, you're laughing, you saw that, right?
Those were nervous laughs. Yes, ma'am, I did see that.
Okay, and in the video, I mean, you heard the testimony of Detective Tudor, right? He has no reason to lie against you, right?
Objection speculation.
That'll be sustained.
And he said that he didn't smell any alcohol on you and he didn't observe any clues of intoxication on you, right?
That's what he said, yes.
Okay. And you see the video, you seem perfectly fine in the video. You would agree with me, right?
No, ma'am, knowing myself and my body language, the way I was slumped over and leaning back, I would say I was still feeling the effects of alcohol last night.
Okay, but you weren't slumped over when you were speaking with him, right? You were able to sit out.
I was speaking, but if you see, I would have my head down like this while I'm waiting for him.
When no one else is in the room, right?
Yes, that's because the room was still spinning.
Okay, but when you're talking to him, you're able to sit upright and have a normal conversation with him.
Yes, ma'am.
And you have the mental wherewithal to lie and make up a story that now you're saying is completely false, right?
Yes.
Okay, so you weren't that intoxicated because you knew to lie, right?
I wouldn't say that any person can lie whether they're intoxicated or not. Any person can have the mental capacity to lie in their mind, whether they want to or not, whether they're intoxicated or not.
Okay, but my question is, if somebody was so intoxicated that they were
slumped over, throwing up. Their mental capacity is not gonna be the same as somebody that's not exhibiting those effects, right? Somebody that's throwing up maybe wouldn't be able to speak, right?
Objection, speculation.
That'll be overruled, if you know.
Go ahead, answer that question.
Yes, if you know.
No, you would not be able to speak while throwing up.
Okay, but you were able to speak, you were able to concoct this entire story that is a lie, right?
Yes, the story was a lie.
Okay, and you were able to relay that to Detective Tudor.
Yes, I was.
You pass the witness, Your Honor.
Just briefly, Judge. And so Tyler, the morning of May 22nd, 2022, you get into bed with Tatiana at about 7 a.m. Is that right?
Yes.
Okay. And how do you wake up?
I wake up to her waking me up, telling me that one of my acquaintances had sent her a news article and asking her if her and the baby were okay.
Okay, so that person asked if she and the baby was okay and knew who to reach out to after reviewing the news article.
Yes.
Okay, so when you state that you're starting to put it together, there's a news article out there already mentioning your name. Is that fair to say?
It wasn't mentioning your name yet, but it was describing an event.
Okay, well, they reached out, there was somebody that reached out to your wife.
Describing an event that a detective was asking me about. They were asking me if I was hurt or if I had been shot and things of that nature through text message.
Okay, but how would this person know to reach out to your wife?
I'm gonna object as to speculation.
If you know.
Sustained.
Okay, so all of this, you're starting to realize like what may have gone on last night.
Yeah.
Okay, and how do you react in that moment?
I hug my wife and I'm crying. I'm telling her I'm probably gonna go to jail, and I'm crying, and I just keep telling her like, no, there's no way, it couldn't have been me. I wasn't there. There was no way, because in my mind I hadn't gone on that street. I was just in denial at first. I was really in denial. Just there's no way. I was just frantic, and then I was just telling her I loved her, was hugging her.
Okay, and a detective reached out to you very early that morning, correct?
Yes.
Before you had even woken up.
Yes.
Okay, so they had identified somebody before you had ever woken up.
Yes.
And they were already looking for you.
Yes.
Okay. That's the witness.
No further questions.
All right, you may step down. Make sure that you leave the microphone behind. All right, ladies and gentlemen, we're going to take our lunch break. We will be back, start back up at 1:30. So remember my previous instructions. Everyone, please rise.